They are a family that looked perfect in pictures. But the photos found on their phone unveiled an alleged gross, disgusting, and terrifying secret. This Florida couple, one a firefighter, one a real estate agent, now accused of the unthinkable. Both are facing several charges, accused of possessing child pornography and several counts of allegedly performing sex acts with a dog. We're on the case, presented by Law&Crime. I'm Chris Stewart. No words for this one. I'm going to be honest with you up front before we go through this episode. This is a story that is not easy to talk about, and it is disgusting what this couple is accused of doing. It's also just scary when you think about this couple and what they presented to the public, but who they may really be. As much as we can say this is disgusting, and certainly what they're accused of is disgusting, it is scary and terrifying, truly an alleged wolves in sheep's clothing, and this is why. Let's get into it. The couple's names, Jordan and Harleigh Hoffman. Now, the couple allegedly, they put up this front where you would not expect them to be accused of this. I mean, it's hard to believe anybody would be accused of this, but this couple, they have children, 2 children, from what we can see in pictures. And they also had good jobs. Harleigh worked as a real estate agent, and it seems from social media, she also lost a lot of weight recently, that she was feeling very confident about herself. Jordan, her husband, he was a firefighter in Columbia County, Florida, where they lived, and now where they are both facing charges, including alleged sex acts with a dog. Now, here's what we know. This story first broke in Lake City, Florida in August when Jordan, the husband, was arrested by Lake City, Florida police. Detectives said there was a tip that came in from the National Center for Missing and Exploited Children. Now, on the surface, he appeared to be a model dad, a firefighter in the community, a first responder. He would post pictures as normal dads would, either working on his truck or being there with his wife for an ultrasound when they were expecting a child. The tip, though, that came in through the National Center for Missing and Exploited Children shattered that image. It unveiled an alleged horrifying reality of who this man may actually be if found guilty. It was about alleged child sexual exploitation material being shared on Snapchat. Now, detectives received this tip and then they went through and tried to trace it back to a number. They said the material was that of a, quote, prepubescent child engaged in sexually explicit conduct. Now, further investigation found that the account was that of Jordan Hoffman, a 33-year-old firefighter in Lake City, Florida. Police say they found that Hoffman was the subject of a second tip that came in related to allegedly sending another image of an unclothed child. Hoffman was arrested and sent to the local jail. After his arrest, detectives got his phone, they analyzed it, and this story became even more disturbing in ways that we could not have expected. Not only did that phone allegedly show more child sexual exploitation material, they uncovered evidence allegedly involving Hoffman's wife, Harleigh, a local real estate agent. And then detectives said not only were both the Hoffmans now accused of alleged sexual material involving children, but animals as well. Specifically, according to court documents, alleged sex acts with a dog. Now, Jordan Hoffman faces numerous counts related to the alleged images depicting him engaging in sex acts with the animal. Local TV station WCJB reports that Harleigh Hoffman allegedly is visible in the images with the animal as well. Jordan Hoffman is facing 57 counts related to what officers say they found on his phone. And you can see in this count, it says on or about August 24th, 2025 in Columbia County, Florida, did then and there knowingly film, distributed, and possessed any pornographic image or video of a person and an animal engaged in sexual contact with an animal. Jordan Hoffman's charges include 35 counts of sexual activity involving animals, 13 counts of possession of child pornography, 5 counts of promoting sexual performance by a child, and other charges including unlawful use of a two-way device and a count of destroying evidence. His wife Harleigh is facing 14 counts, and that includes 8 for sexual activity involving animals and 5 for possession of child pornography. Now, there are still a lot of details that have yet to come out, including what relation this couple had to their alleged victims. Now, we do know that they were parents. Harleigh posted TikToks with their kids. They were seen out on Christmas, like so many families do, taking pictures in front of a tree. Harleigh's employer, though, posted this statement on their social media. It's a local real estate company, and it was in response to her arrest. It reads, quote, "We are aware of the recent allegations made against one of our now former realtors. Southern Integrity Realty does not condone or support the behaviors associated with these allegations. We are committed to upholding the highest standards of professionalism and integrity within our organization and promoting safety within this community we love." Court records show that Harleigh Hoffman waived her arraignment. She entered a not guilty plea to all the charges that she is facing, and it reads that she's demanding a jury trial in this case. Jordan has yet to enter a plea according to court records. He is next expected in court on October 1st for a hearing where he is demanding his bond be lowered. Do you ever notice how some habits just sneak into your day without you even realizing it? For a lot of people, that means reaching for something on autopilot because you're stressed or run down, even though you know it's not good for you. Which is why I want to tell you about our sponsor, Fume. Fume is an award-winning flavored air device that's great for combating oral fixation and fidgeting. It delivers great taste as your usual pick-me-up without any harmful chemicals. Instead of inhaling vapor, you simply breathe in natural, non-toxic flavors that satisfy the craving without the downside. Fume isn't about quitting, it's about replacing. It's a flavored air device that gives you the same hand-to-mouth habit, but without the downsides. There's no vapor, no nicotine, just natural, non-toxic flavors. Now, what I love most is really the design. It's a sleek wooden piece that feels great in your hand, and the magnetic fidget features are surprisingly satisfying, perfect for when you're stressed or you need something to keep you focused. Plus, it's portable, so you can take it anywhere. One flavor a lot of people love is crisp mint, super refreshing, perfect for keeping you sharp throughout the day. But there are a ton of flavors to choose from, so you can find your favorite. More than 500,000 people have already made the switch to Fume as part of their habit change journey. So if you're ready to try it for yourself, now's the time. For a limited time, if you order the Journey Pack using my code, you will get a free Fume topper, which is an awesome accessory to level up your experience. So click the link, tryfume.com/law&crime, or scan the QR code on your screen to get yours today. Both Jordan and Harleigh seem to currently be held in the Columbia County Jail. Now, I can also see with online court records that there are active custody cases in family court in Columbia County where it appears extended family members of the Hoffmans are filing to take custody of their children as they're now facing these extreme charges and accused of unthinkable actions. Now, this story is shocking, and there's no way to understate that. Even if they were career criminals, what they're accused of would be unthinkable. But on top of the good jobs and appearing to be a happy family, the Hoffmans have no serious criminal record other than previous traffic issues. Joining us now to talk more about this is criminal defense attorney and former prosecutor Kathleen Bogenschutz, joining us from Florida. Thank you for taking the time to be with us on Law and Crime. I know this is not a fun story to talk about, to say the least. 70 charges in total between this couple. It's 57 for Jordan Hoffman, that his wife, Harleigh, roughly 13 charges for her. What does that tell you about the evidence that prosecutors have against the couple in this case?
So most of us don't think like offenders in our daily lives, and for good reason, and I'm glad we don't. But this is something that when I was prosecuting sex crimes, we used to talk about every single day. What do you need in order to, if you were inclined to do so, to victimize a child like this, to victimize animals like this? You need access to the victim, and you also need privacy. So if you have one without the other, you can't do it. Lake City is we're a much more rural area in Florida. And it would not shock me that they had the privacy to be able to do these kinds of things and to create this kind of stuff. You wouldn't expect somebody to be creating it someplace where, you're in an apartment building with thin walls, things like that. You need to have the access to the victim, and you need to have the privacy to be able to do it, particularly in this kind of, I hate to say prolific kind of a way.
Because if someone was found with one video of what they're accused of, which is bestiality they're accused of, as well as child sex abuse material. Right. One would be, I would assume, prison time and would be a very, very serious offense. But when you're facing as many as they are, how would cases like that differ, knowing that there is just so much that they apparently have on this couple?
Well, it's actually a really good point that you make, because unfortunately, I mean, it's great when technology improves over time for us as people, usually. But yet back in the day, like back in the 90s and the early 2000s, if people were trying to exchange videos like this, I mean, they were sending CDs through the mail. They were sending those old floppy disks through the mail. And these days, computers are just capable of so much, and cameras are capable of so much, and you can fit so much onto one little SD card and trade it over the internet so easily, that we have seen just a real increase in the number of videos and photos that individual offenders have had on their devices, just as technology has improved, which kind of makes sense. The sentencing guidelines, however, have not changed that much. And I would expect to see some pretty significant, at least under Florida sentencing guidelines. I'm assuming that we would be dealing with aggravated child pornography. We've got multiple charges, and then we're going to end up with minimum mandatories based on that.
What if you had to ballpark the type of prison sentence that they could face? What type of time would they be looking at?
So Florida has score sheets, and it's basically so former judge that's a public defender, former judge that's a prosecutor. You get almost like a sentencing guideline range, and in this case, I would expect that it is entirely possible that at least the male of the two with the larger number of counts may score in the range. I could sit down and work it out with a pencil and paper. But he may score in the range of a potential life sentence. In Florida, if you score over 360 points, not months, points, the judge could sentence you to a life sentence.
And it's just, there's a lot of this story that's shocking. I mean, I think even, their professions, they seem to be on the surface kind of like model citizens, but then there's all of this. And even with what they're accused of, like they could be career criminals and it still would be shocking that someone would do this stuff. But, and of course we'll see how they're innocent until proven guilty. I want to say that. But when you look at this case and you prosecuted sex crimes and the fact that there's this bestiality element to it as well that they're accused of, I mean, how common is a case like this?
I can tell you that, and I was assigned to do sex crimes for 8 of the 12 years I was a prosecutor. I think I have only seen 2 or 3 bestiality cases, and keep in mind that I was also in an office that for 4 of those years, that is the only thing I did. Those are the only kinds of cases that were assigned to me, so highly unusual. Not saying it never happens, but there's reasons, there's laws against it, let's put it that way. And I will also make this other point, they look like upstanding citizens. Something that a forensic psychologist said to me years ago has always resonated with me, and I pass this on for the parents of other small children, as I have a young daughter as well. If monsters looked like monsters, they would never be able to get close enough. So, if somebody looks dangerous and scary, they're probably not going to be able to get close to your kid or close to you. And I hate to, espouse paranoia, but this is why we keep our radar up as parents and as people. And this is why we don't let our kids go over to other people's houses without supervision and making sure we know who they are.
Yeah, and that's a really profound kind of way, because I haven't necessarily, I mean, we cover a lot of cases, unfortunately, where it's the kind of the wolf in sheep's clothing is the cliche line. And then it's like you look at this one and it's a family of 4 and we don't know if their children were involved in this. But, they just look like normal people with normal jobs. And then you read the court documents and it's just, they're accused of being monsters. And I think the other part of it too, for me, that I find in cases where you have not just one member of the family who's accused of being involved in some of this terrible stuff, but you have a second person in the family who's involved allegedly in this stuff. And it's just, what is the dynamic that you see in some of these cases involving couples where it's like you have two people who are predators, allegedly, who have found themselves in this world, and then they continue on and then eventually find themselves in cases like this?
So I'll show my age here for a second. I think I'm a bit older than you are. Back in the 90s in Canada, there was this case, it was called the Ken and Barbie killers. And the prosecution gave this sweetheart plea deal to the female of the two because they were allegedly abducting and sexually assaulting females together and eventually killing some of them. And the female got the plea deal, the benefit of the plea deal, and got a couple of years in prison, I think, with light at the end of the tunnel, and has been released since. And then they found the videos of what was happening, and apparently she was participating in all of it. It's always a question mark. And another thing that, an old homicide prosecutor told me when I was trying to find some meaning in a case, and he said, if you try to impose your logic on something that defies it, you're going to just drive yourself insane and accomplish nothing. So, I mean, we've seen these male-female teams work in the past. There's even video footage of it from back in the 90s, and of course that would have had to have been one of these type cameras. But they were filming their exploits with these girls, and it turned out that the female of the couple was just as involved. Now, she claimed in that case it was Carla Homolka, and the male's name is escaping me, Paul Bernardo, I think. But she was claiming to be the victim of domestic violence. There were these pictures of her with her eyes punched out. So there was this kind of decision made by the prosecutors that one of these two is more culpable than the other, and that maybe she was, there was some kind of Stockholm syndrome going on when she was participating to it, and then they found the videos. And there was kind of a public outcry to revoke her plea offer. And I think in Canada it was the Crown prosecutor, but they stood by their plea deal. But I mean, we have seen these kinds of like folie à deux type couples happen in the past. I'm not saying that's what happened here. It's entirely possible that, we've got one out of the two that has significantly more power in the relationship. But, I mean, we'll just have to wait and see.
Because just based off and that's an interesting point about domestic violence and certainly there's relationships that involve domestic violence that are incredibly serious. In this case, you have, Jordan is facing 57 charges. His wife, it's 13 or 14 charges. All of them serious charges that she's facing, but it seems that he was far more involved based off the evidence than she was. Yet, I know that there's a local TV station saying that she was seen in the video, so she is there. How could the defense, how effective is that defense if they go with, well, he was the one leading this was, maybe an abusive relationship, he had the power in the relationship, and she was just kind of there, trapped part of it? I mean, how effective can that be in a case like this where, if you show this video, which we haven't seen it, not that I think anybody would want to see it, but if you show that video to a jury, it seems like that'd be a very strong piece of evidence against her.
So Florida has a theory of prosecution called principal theory. And the way that I used to explain it to juries is that the Nuremberg defense doesn't fly in Florida. Like, I was just following orders, this guy told me to do it, so I did it. Or I only pulled the lever, I didn't shoot the gun. If you take some part in the offense, you are responsible for all of the offense. So, or if you really want to work it down into colloquialisms, if you're in for a penny, you're in for a pound. So in front of a jury, that argument should not carry a lot of water with the principal theory instruction. But it may hold some water with the prosecution in deciding if one of the two wants to turn state's evidence and testify against the other. And it would appear that these two are married. So then we also have issues of spousal privilege. Now, I will also note that there are important exceptions to spousal privilege in Florida when a child is victimized or when there's domestic violence. So, basically you can't terrorize your family and then claim spousal privilege.
I did see in court records where she waived her arraignment and entered a plea of not guilty. He has not, so he's still slated to have his arraignment. I think it's October 1st. What would you read into that? What does that tell you about? Is there anything to take away from how both, if they're going to be tried separately, how these cases could go?
So they obviously can't be represented by the same lawyer. I don't know if the public defender's office was appointed to her, and then another attorney maybe off of the wheel. That's what we call it, the wheel. Like a private attorney would be a specially appointed public defender, or he would get conflict counsel, essentially, to represent him. So that could be the explanation as to why she was able to enter a plea and he was not. There's a bunch of steps of bureaucracy that you have to go through when the public defender's office conflicts off a case. So I haven't looked it up to check that she has a public defender, but that's my first suspicion, that he's kind of winding his way through the bureaucracy to get his own lawyer appointed.
And I know you're a criminal defense attorney as well. And I think for Jordan, the husband, facing 57 total charges, these were tips that came in through the National Center for Missing and Exploited Children. Apparently, prosecutors have some very damning evidence against him. What's the defense? What's the strategy you take when you have a client that it seems like prosecutors would have him, and of course he's accused at this point, we haven't seen the evidence, but they would have him dead to rights that you have this child sex abuse material on your phone and your wife is allegedly in the videos as well. And there's the bestiality element to it too, which makes it even more shocking. So
the first move that I would be making is to examine the search warrants, because there's probably multiple levels of search warrants that were done in this case. I'm not saying anybody did anything wrong, but that's your first move as a defense attorney. Just because it's a truly disgusting, stomach-turning crime doesn't mean that they don't deserve the same protections under the law that we all do. So I would be looking at the search warrants. I would be double checking that the things that they applied for the search warrants for were actually criminal offenses. I actually have a case like that open right now, where the police applied for a search warrant and then never charged the guy for the first crime because they decided they didn't have probable cause. And I went, yikes, that doesn't sound like it had, that doesn't sound like it was a very good basis for a search warrant, and we're going to be litigating that. So that's your first move. Your second move is to see a lot of times when you have a family and they're all using different devices, like who actually had access to it. Now, because we have cell phones with Face ID and stuff like that, that might fail really quickly for purposes of saying, oh, somebody else was in my phone, or it's Face ID, and computers and phones have the ability to, like, for example, my MacBook now can read my fingerprint to open the computer, and you can look through the past events to show whether it was my passcode that I typed in or whether I used my finger, and one of those two is far more likely to be personally me. So depending on what kinds of devices they have, you might be fairly dead to rights, and it might be time to negotiate. But it doesn't mean you don't kick the tires as a defense attorney. It doesn't mean you don't read through all the warrants. I have seen some very stupid mistakes made by some very smart police officers and prosecutors in the past.
And if at the end of the day, you look and everything was done by the book, they have him, let's just say, if you're a prosecutor, why, I guess this goes to the defense attorney part of it. What leverage is there to get something better than going to trial and knowing that you could get a conviction and holding him to the highest level of the law?
So the first thing that you could look at is there anything that I or my client can offer you, the state, in exchange for a better plea deal? One of those things, and unfortunately, people like me think this way because that's our job. But one of those things is that when you have children that are the victims of these offenses, not making them testify and not making them go to a deposition is something that the state is often willing to negotiate for. So you have that conversation with the prosecutor and you say, look, I think all these search warrants are in order. I can't make a motion to suppress with a straight face. I deposed all the cops. Everybody looks like they're on the up and up. If I choose not to depose the child or children in this case, like not to ask them questions, not to make them talk about it, what kind of a plea deal would you be offering me to not do that? And in some jurisdictions, there's like an unwritten rule that if you depose the victim of a sex crime, that there's no more plea offers. That's a really bad general rule to have, because sometimes your case collapses in on itself like a neutron star as a prosecutor. I think back to, I think it was one of the guys in Hollywood that said never work with children or animals, because you never know what's going to happen. And in fact, when I used to prosecute cases with children, to a case, I always put the child on first and then used the rest of the witnesses to clean up whatever the heck just happened with the kid on the stand, because, you know, it's just very difficult to control children and to be able to make them talk about what will hopefully be the worst thing that ever happened to them in front of a courtroom full of people. So that's part of the negotiation there. There's also whether there were statements made by the child. A lot of times there are forensic interviews that are videotaped, so you already have a pretty good idea of what the kid's going to say, and you can go through that with your client and try to sit down and try to you know, have a difficult conversation about the strength of the evidence here, which I think a lot of defense attorneys neglect to mention when they're talking about how you do cases. A lot of this job is making very difficult decisions and having very tough conversations with your clients.
Yeah, and that's going to be certainly a part of this going forward. Such a disturbing case out of Florida. But Kathleen Bogenschutz, it's always great to have you on Law and Crime.
Thanks for having me.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.